Chapter 12 by Catherine Brooks is that the child should not have the right to refuse medical treatment to which the child's parents or guardians have consented. She starts by saying the law does recognize the right of adolescent patients to make medical decisions in an important but limited number of circumstances, where the patient has proved maturity sufficient for the decision of where other governmental or community goals are met, by allowing the adolescent patient independent access to physical and mental health services. To create greater legal rights, she argues, in the child to refuse the care consented to by his or her parent is to place the parent in an unreasonable position of ongoing responsibility where his or her guidance carries no weight. To enlarge this remedy beyond the existing limits, furthermore, is to ignore the preparatory role of childhood and adolescence for a person's adult responsibilities. Finally, it's also an expensive and inefficient use of court resources. All right, in the first section, speaking the language of rights in the vernacular of the law, Brooks outlines the strategy she will pursue. She says her first section will address how the law recognizes medical decision-making in the family, and then the second section addresses the law's concerns with decision-making capacity, and the third section addresses medical decision-making for and by children and adolescents that takes into account parents' roles, the law's expectations of medical practitioners, and the need for children and adolescents to have time to practice decision-making without being required to bear the legal and personal burden of errors in judgment. All right, a foundation in law, the child and the parent. There's 4 critical Supreme Court opinions to understand, says Brooks. First, in Meyer v. Nebraska, the court addressed the nature of legal protection to be afforded parents in raising their children. This dealt with whether kids could be taught German in a state or whether the state had any business regulating them getting taught in German. 2 years later, second decision, in Pierce v. the Society of Sisters of the Holy Names of Jesus and Mary and Hill Military Academy, the Supreme Court again gets asked about parents' rights to make decisions for their children without state intrusion. This dealt with whether people could educate their kids in private schools or whether they had to send them to a public school. Third, in 1944, the issue of parents disregarding a state law enacted to protect children from danger while at work was presented in a third case called Prince versus Massachusetts. And the details of the case are kind of interesting, but the famous statement is this. Observing that parents may be free to become martyrs themselves, the court held that parents could not make martyrs of their children before they have reached the age of full and legal discretion, when they can make that choice for themselves. Finally, a fourth case, Parham versus JR&JL, gave the court an opportunity to address directly the decision-making power of parents in seeking medical care for their children. As Brooks explains, in this decision, they were looking at the institutionalization for certain children in medical facilities, like mental health facilities particularly. And Brooks tells us, in rejecting additional safeguards for the child patient, the court found that the natural bonds of affection that parents have for their children and the likelihood that parents act in their children's best interests in making decisions about their medical care were sufficient to protect a child from unnecessary institutionalization. Parham, this fourth case, has come to stand for its legal conclusions that not only do parents have the right to raise their children as they see fit, free from undue state intrusion, but also that parents are presumed in law to act in their children's best interest in making medical care decisions. However, Brooks notes that such deference is not to say that parents are free of limitations in their medical decision-making about their children. She gives 2 main examples. She gives some discussion of how states have safeguards to protect children from harm and neglect by their parents, or for those standing in a parent's place, and other limitations on parental medical decision-making, Brooks reminds us, arise from the nature of the medical issue that the child presents. So here it's not a matter of neglect, but an issue-by-issue analysis. A number of states, she says, have statutes allowing medical decisions by minors for particular medical conditions or services without the knowledge or consent of their parents. And then she gives several examples. In some, she says, the law recognizes in parents the right to raise their child without intrusion from the state, absent an important reason of state purpose for that intrusion. In the section on the law, psychology, and neurology, subtitled Consent and Refusal to Consent, in other words, dissent, Brooks writes that the law has a long history addressing the question of consent, and in medical care in particular, this requirement that a person consent to any treatment upon him or herself follows a common law rule that a person has a right to be undisturbed in his or her physical self, and that an unconsented touching may be grounds for recompense in law. Now, in deciding the sufficiency of the consent given, Brooks tells us, the courts examine the quality and the thoroughness of the information provided to the patient by the medical provider about the contact, in other words, the medical treatment, and the contact's known and knowable consequences. She says that the courts also consider the ability of the patient to make a valid consent, to understand the information that has been given. Even adult patients, however, Brooks notes, having received the fullest information available about medical treatment from the medical care provider, might be subject to influences that make consent less than voluntary. She gives various examples, some of them dealing with pressures about the cost of your medical care and who's going to pay for it. She says matters involving children, however, are often expedited in the courts whenever there is pressure, with priority given to the children before other calendared cases. In particular, she notes the question of the maturity of the pregnant teen is one that is often heard almost immediately upon the filing of the case. Now, much has been learned, she points out, in the last quarter century from social science research and from neurology. In social science research, particularly the areas of developmental psychology and the progress of much has been learned in the last quarter century, she says, from social science research, particularly in the areas of developmental psych, about the progress of the person through childhood and adolescence in acquiring the skill and understanding necessary for mature decision-making, which is required in law for valid consent. And she talks about a MacArthur Foundation study. Discussion of minor patients' medical decision-making can benefit from the investigation into the decision-making of minor clients within the legal system, like the juvenile court system. Each aspect of the legal decision-making process, and she talks through several of these aspects, for a client in a juvie has an analog in the medical decision-making process for a patient, whether we're talking about juveniles or adults. And she gives several illustrations of this. And so some interesting MacArthur Foundation findings are kind of instructive. Impulsive, sensation-seeking, risk-seeking, preference behaviors all improve with increased age and adolescence. But preference for risk peaks at ages 16 and 17 and then decreases into early adulthood. And then some other interesting findings about impulsivity and sensation-seeking and the amount of time given to the thought before taking action, directing your thinking to the future, and the ability to delay gratification. These things improve with increasing age into early adulthood. And she notes that neuroscience studies of the brain's development through childhood and adolescence provide some support for these MacArthur study findings. All right, in this section on the right to decide, consent, and the refusal of consent, Brooks says, for all other medical decisions, besides the two dealing with pregnancy and some public health interest where a minor is involved, there is no real clear policy in law about allowing minor patients to act on their own behalf by consenting to or refusing medical care. She says there are a number of instances where courts have addressed the question of whether a minor's consent to treatment or refusal will be given legal effect, but no single line of responses points to the development of a national policy. One of these examples comes from In Re E.G. Absent the issue of pregnancy, there are just a few reported cases in which the minor patient is deemed in charge of his or her medical care, and one of these cases involves a refusal to accept treatment by an adolescent who was close to adult age. In this case, In Re E.G., 1989. She didn't want to be treated with a blood transfusion. In her case, she was close enough to the late age of majority, and her parent was in favor of her refusal. So there wasn't a conflict with her parent on this, just kind of a conflict with the medical establishment. But the case illustrates an exception known in the law as the mature minor doctrine. And Brooks says this doctrine was discussed by a professor named Walter Wadlington in an important seminal article in 1973. Here, the categorical age-based consent rule gives way to the minor patient's desire to control his or her medical treatment when that minor patient can demonstrate to a judge the necessary maturity for medical decision-making and good cause for the parent to be overruled. Okay, now a second case, or type of mature minor case, exists under a rubric of what's called the emancipated minor. And Brooks tells us emancipation ordinarily occurs at the age of majority, freeing a person from the constraints that are imposed by parents and freeing the parents from the duty to support their child. In recognizing a minor's right to decide medical care, Brooks says, the law protects that minor patient from bearing liability for the consequences of those decisions, financially, physically, and psychologically. In conclusion, Brooks writes that the common law doctrine of necessaries demands the parent to be responsible for the payment to third parties who provide the necessaries of life, including medical care, to her child. Now, when parents attempt to provide care and their child refuses it, parents are required to overcome their children's resistance without causing harm to the child, says Brooks. Parents may be removed, says Brooks, from the medical care treatment of their child by the state because their medical care choices do not comport with the prevailing medical advice or practices in the community at that point in time. However, says Brooks, when the parent is removed by the child patient's choice, not because of any wrongdoing or lapse of the parent, then there's no provision in law for any substitute care. Most importantly, Brooks reminds us, the law allows for childhood and adolescence to be a time of learning. And I'll talk about the last paragraph in my comments.